Good afternoon and welcome to ESOP Basics, what you need to communicate to owners. My name is David Hall. I'm the firm manager here at Hall Benefits Law, and with me I have Leah Singleton, our Director of Legal Operations, who will be presenting today. I wanted briefly to mention that there will be a 5-question survey both immediately after the webinar is completed, if you'd like to complete that on your computer after the webinar, and that will also be emailed to you afterwards. Any attorneys in attendance, we will be providing CLE credit for this webinar, so please email admin@hallbenefitslaw with your bar number and we will make sure that you are awarded that CLE credit. Our presenter today, Leah Singleton, has practiced in employee benefits for 15 years. She uses a practical and business-focused approach to advise clients. She advises corporate, governmental, not-for-profit clients on all matters relating to employee benefit plans and executive compensation, from plan design and implementation to plan termination. So the next slide here talks about the structure of today's presentation. Leah will be going through what do you have to tell employees, what information can you keep from employees, what should you tell employees, and what are the legal risks of communications to employees. In addition, I think this will be a great opportunity for folks who don't know much about ESOPs to learn some of the basics. So Leah, take it away.
Thanks, David. So before we dive into the program, I just wanted to give a little background of what an ESOP is. So an ESOP is an employee stock ownership plan. It is a retirement plan, a qualified plan like a 401k plan or a pension plan, except that instead of investing in money or having employees put money into the plan consists entirely of company stock. And so the participants in an ESOP actually are the owners of the company through their participation in the plan. So sometimes you hear the employees called employees. Sometimes you hear them called owners in a corporate context, that the same employees would be owners, and sometimes you hear them called participants in the ESOP plan. We're all talking about the same group of people, whether we say employees, owners, or participants. So an employee stock ownership plan, to me, has always had a little bit of a misnomer of a name. I think it should really be called an employee stock sort of ownership plan, because the ESOP participants don't have the same rights as a traditional corporate shareholder. While the company stock is held in the ESOP, the stock itself is actually owned legally by the trust of the ESOP plan. So the trustee is the person who has the control of the stock, and the employees just have the benefits of the stock without all of the responsibilities of being a stock owner of the plan. So ESOP participants, while they are owners, they are beneficial participants in the ESOP trust. They don't have an automatic right to participate in company management decisions just because they are ESOP participants that own employee stock. And they don't have a right to make decisions as to how the company should be run on a day-to-day basis. So that brings up a question that I hear a lot in my practice about what do you have to tell these employees? So they are stock owners in the company, they're participants in the ESOP, the employee stock ownership plan, but what do we legally have to tell them? Because sometimes when a company is deciding to implement an ESOP, one of the reasons that they don't want to implement it is because they don't want the employees to have all of the financial information of the company or all of the details and in the weed kind of information that go along with company financials and company operations. And so that's what this seminar addresses today. So one of the things that is absolutely required to give to these employees or participants is something called a summary plan description. This is actually an ERISA requirement, and a summary plan description is exactly what it sounds like. It is a summary of the plan, and it is supposed to be written in common everyday language so that any person can understand it. That might be a joke to some people because you're trying to describe very complicated tax and ERISA concepts in everyday language, but the intent is for any person to be able to pick up the summary plan description and understand the key features of the plan. It provides information about the people who administer the plan and other things about the plan, what it takes to be eligible in the plan, what happens when you terminate employment, what happens to your benefits in those situations, what happens if you're disabled, what happens if you die. That's what a summary plan description has in it. It has to be furnished to the employee no later than 90 days after the employee becoming a participant in the ESOP, and the summary plan description, or SPD, must be updated and redistributed every 5 years. If the ESOP or the plan is amended before that 5-year period of time, then the SPD needs to be updated, or a summary of the changes that were made to the SPD need to be handed out to the participants, and there's a legal timeline for that as well. So that is, summary plan description is one thing that you have to give participants, and it is just a summary of the plan terms. A summary annual report is the second thing that is absolutely required to be given to these ESOP participants. A summary annual report is a summary of the financial aspects of the plan. Every year, the plan has to file an IRS form. It's called the Form 5500, and it is a tax form, much like individuals have to file our taxes. Plans have to file their tax returns as well. The difference is the plan doesn't have to pay any taxes, but this form includes all the information about the liabilities of the plan, plan expenses, and plan assets. So what the summary annual report is a summary of all of the information that's in that very complicated tax form 5500. Even though it's an IRS form, it's filed with the Department of Labor each year. The IRS and the Department of Labor jointly oversee that tax filing, and the summary annual report just provides a summary of the plan assets, any of the financial transactions, the number of participants, and things of that nature that just gives an overall view of the financial health of the plan, not of the company, just of the plan itself. And there's some legal time frames that has to be given to participants as well. So we understand that SPD has to be provided to plan participants that gives a summary of the plan terms. A summary annual report has to be given to participants that provides a summary of the total financial health of the plan, not the company. And then individual benefit statements have to be given to participants that explain to them their individual account balances and what they are entitled to receive under the plan. So the individual benefit statements are tailored to that particular person, and it calculates their retirement benefit based on their date of hire, how many years they've worked, their compensation, anything of that nature. It also includes a vested percentage of their account. So these individual benefit statements are required to be given to the employees and the participants as well, and there's some legal time frames about when that has to be given to them. The next thing that you absolutely have a legal right or a legal obligation to provide to plan participants is a disclosure of the fees that ESOP participants have to pay. Now, the thing about an ESOP is it is different than a 401k. An ESOP is invested in the company's stock. So typically there's not any fees associated with that stock. There's no 12B1 fees or advisor fees that are associated with the stock of the company. In some situations, an ESOP plan can be designed more complicated so that it invests in other things besides the company's stock, and in that situation, that is when this requirement pops up, is that any any fees or expenses that are provided to advisors, the participants are entitled to see what they're paying for those services. Like we said, usually an ESOP plan doesn't fall under this, but I left it in this description because it can have features that require this type of disclosure. Okay, so the next thing that participants have to be given is voting information. So for a private company, remember the ESOP trustee is the legal owner of the stock. Remember, I call these plans employee stock sort of ownership plans, and that's because the trustee is who owns the plans, and the trustee is who owns the stock instead of the employees. And so the ESOP trustee is who actually votes based on the shares in the plan. The plan document will have some language in the plan about how the trustee has to vote on different things. Pass-through voting means that the ESOP participants are given the chance to see what the issue is, decide how they particularly want to vote their share, and then tell the trustee, hey, I want you to vote my shares this certain way. The plan document can say that the trustee has to vote the same way that the participants ask them to vote, or the plan document may, in the alternative, have language that says that they look at the majority of how the employees directed them to vote, and they vote all the shares in the same way. That being said, even though employees can be given the right to have this pass-through voting, the ESOP trustee is still a fiduciary and has to always act in the best interest of participants. So if the trustee feels like or has a reasonable basis that a decision needs to be made that is contrary to what the employees told them to vote, the trustee has an absolute obligation under the fiduciary rules of ERISA to act in the best interest of participants, even if it's contrary to what the participants told them to do. Okay, so when do we have to let ESOP participants vote? They don't have to vote on everything, and you certainly don't want to give your ESOP participants all of the information about your company to have them vote on all of the minutia that goes on, like whether a company is going to expand or borrow more money or things like that. Should not go to the ESOP participants. They're not legally required to go to the ESOP participants. So the law under the tax code says that there are certain major corporate events where ESOP participants have to be given a right to vote. Again, the trustee has an obligation to vote in the participants' best interest, even if it's contrary to what the participants told them to do. But the participants at least have to be given a right to vote on these things, and I've listed them in your slide. One is a merger, a consolidation, recapitalization, liquidation, sale of substantially all the corporate assets, a dissolution, and a reclassification. What's very important is in this list, there's no requirement that a participant have a voting right on the sale of stock for cash. The trustee can make that determination, and that's important when a company goes to sell its stock to perhaps another company. The participants may not necessarily be given the right to vote on that if it's purely a stock sale for cash. Okay, so we've talked about the things that have to be provided to the participants without them asking. You just have to do it. There's legal time frames in the law about when that information has to be given to participants. This slide talks about things that must be provided only if the participant asks for them. So if the participant asks for a copy of the plan document, an SPD, their beneficiary designation, or the Form 5500, you have to provide them generally within 30 days of receiving a request. So these are, you would normally give out the SPD. You have to give out the SPD within certain time frames, but if they lose their copy or want another one, you have to give them another one. The other three things, the plan document, the beneficiaries, and the Form 5500, including schedules, we don't normally give to participants anyway, but if they request them, you have to provide them. The company can charge a reasonable copying cost or fee to provide those documents, especially since some of them are very lengthy and in the hundreds of pages. And then if the ESOP plan does not comply and does not provide these documents within 30 days of receiving a request, the Department of Labor can impose a per-day late fee for not providing those documents. And the per-day fee for not providing a plan document is $110 a day. So it can be pretty egregious. Okay. So we talked about what information we have to provide employees automatically, what information we have to provide them if they ask for it. So what information can I keep from them that I can keep secretive? So other than these ERISA required disclosures that we talked about, it's up to the company to decide how much or how little information to provide to the ESOP participants. As far as the company's financial information, there's no legal requirement to provide ESOP participants with copies of the company financial statements, and you don't even have to make them available for inspection by them. It's really none of their business. Think about it, if you were a stock owner of Google, I mean, you're a shareholder of Google, you don't have access to every bit of their financial information as a regular shareholder, and the same thing applies to ESOP participants. So there's no formal requirement to provide any financial information about the company. So in an ESOP, since the most ESOPs are used by private companies, their stocks are valued each year. And the stock has to be valued each year so that you can provide a benefit statement to tell a participant how much money they have at retirement. But there's no requirement that you give the ESOP participants what the per share value of the stock was. They can probably figure it out if they look at their benefit statement and see that they have X amount of money and they have X number of shares. They can do the math and figure it out. So, but there's no requirement that you provide them any information as to how the dollar amount value of the stock was obtained. Okay, here's a list of other things that I've been asked in my past. Do you have to provide these to participants? Do we have to give them a copy of the company's financial statements? No, you don't have to do that. Do you have to disclose how much money officers make and other employees make? No, you don't have to do that. Do you have to explain to them the ownership structure? If there's joint ventures or a parent that owns some stock as well? No, you don't have to explain any of that. Do you have to tell them any equity-based awards? So maybe the ESOP doesn't own 100% of the company. Maybe it owns 75% of the company, and the other 25% of the company is given out to officers in the forms of executive compensation, such as a restricted stock or something like that. You don't have to tell the ESOP participants any of that. They don't have a legal right to that information. Company tax returns, nope, they don't get those either, unless you just want to give it to them. Real estate leases or equipment leases or any of that information, the ESOP participants do not have a legal right to get. Information about how many shares are allocated to participants, you do not have to explain to them, other than what's in the summary plan description, how each participant gets money under the ESOP, and you don't have to give them copies of the ESOP appraisal report or valuation, especially since those reports can contain sensitive financial information that you definitely would not want distributed to your competitors, or you just would want control of that information. So here's just a summary, a recap of what we just talked about. What do you have to disclose? You have to tell them their account balance. You have to tell them what percentage they're vested in their account balance. You have to tell them the per share value of the stock that's in their individual benefit statement, so they can see how much money they have in the ESOP. But you do not have to disclose financial statements, valuation of the total company, and salaries of officers and other employees. So we've kind of talked about the far left side, what you have to tell participants, and the far right side, what you don't have to tell them. So we're kind of talk about it in the middle, like what's a good idea to share with employees. So the whole concept of having an ESOP plan is intended to incentivize employees to take ownership in the company and help it grow and help it be profitable. So what should you tell employees to align with that objective? So, like I said before, you are not required to share all of the company's financial information, but you may want to share some things about how the company grows and how it is profitable, because that can be a very powerful management and motivational tool. You may not want to disclose every single bit of financial information about the company, but you might want to explain or disclose certain aspects that could be used as a motivational tool and help them understand how to make the company more profitable. So strategic sharing of financial performance can help management and productivity. The ESOP valuation, which is the valuation of the company, you may or may not want to disclose that. It may actually help employees understand what makes the company valuable so they can focus on how to make the company profitable. But on the other hand, you may be giving out information to employees that could be detrimental to you as a company if it was not kept confidential. So you just kind of have to weigh the pros and cons of these things on an individual basis. Your whole goal is to motivate employees to increase the company value, the value of the company. And so you just look at all of the information with that lens as to what will actually cause the employees to have more motivation compared to what could be detrimental to the company, and make these types of decisions. I will say that transparency, employees usually have more confidence in a company that is transparent and doesn't hide the ball. And it also makes it harder for someone to claim there's a hidden agenda or the officers are only out for themselves. So ownership in an ESOP does not mean unlimited access to business information, but the company may want to provide quite a bit of this information to help their employees. So if you're going to communicate this information to participants, especially the information you're not required to communicate it, how would you do it? There's ways to do it throughout the year through newsletters, meetings, CEO messages, or manager training and retreats. And you can even have things called Employee Ownership Day or Employee Ownership Month, things of that nature. You can have employment events where certain aspects of the company are communicated through an interview, orientation, reviews, eligibility to participate in the ESOP, certain different time periods for the company, certain time periods that a participant gets more benefits under the ESOP may be a good opportunity to explain, okay, here you are at 100% vesting, so this is how the company's valued, and this is how what you do makes an effect to the bottom line. A funny thing about being fully vested is I heard about a company that when their participants became 100% vested, they got a Columbia fleece vest on their vesting date, and so that's kind of a neat little anniversary or way to incentivize employees. You can also distribute this information through mailings, the internet, frequently asked questions, employee hotlines. You can have special events like the fully vesting event where the employee got a vest and things of that nature. One thing as an attorney that I have to stress is whenever you talk about potential growth or whenever you give information to employees like this, you have to ensure that there are no promises. You want to acknowledge the risk, but you need to link the risk and the reward, because you don't want to be on the record of promising that the company has grown X% over the past 2 years and will continue that trajectory. Those are the kind of statements that make attorneys sweat, and we don't like to be sweaty, so be very careful with that. Another thing that is helpful is to establish an ESOP communication committee. And I've seen some companies do this. This is not a legal requirement, but it actually helps the employees to feel engaged and involved if they are on the committee themselves. And so the ESOP Communication Committee looks at the information and decides what should be disseminated, how it should be distributed to employees, and the whole goal is to implement a strategic vision of employee ownership, that what the employee does in their day-to-day job actually has an effect on the bottom line of the company, which has an effect on their retirement benefits. The ESOP Communication Committee is not a fiduciary unless it takes actions that are fiduciary in nature, such as controlling plan assets or making plan decisions. But as long as they are just deciding how to communicate things to employees through maybe an employee ownership day or a luncheon, or they develop the information that a new hire has and they sit down with the new hire to explain the ESOP. So the goal is to lead employees to act as the owners of the company. And the ESOP Communication Committee can be a great liaison for that, to help train employees and to train management that everyone has a stake in the company's growth and future, and that is realized through their retirement. They can also provide proactive and education materials, and if you do have an ESOP communication committee or think about have one, you really need to do it the right way and have a charter or bylaws and actually have objectives and a structure for how a communication committee works that is based on some procedures. So, we talked about what you absolutely have to give participants: the summary plan description, which is a summary of the plan terms. You have to talk about this. You have to give them the summary annual report, which is a summary of the Form 5500 and the financial health of the plan. Again, not the financial health of the company. You have to give them individual benefit statements that explain to them what their benefit is under this retirement plan based on the stock value. And if there's any fees and expenses that go to advisors, you have to give them copies of that as well. And then if the employee asks for certain information, we talked about what you had to absolutely disclose. Then we talked about things that you're not required to disclose. All of the company's financial information, salaries, things of that nature. Then things you may want to disclose. So this part deals with what are the legal risks of communicating to employees more than the legal requirements. So I made a list of the common legal actions that we see that involve ESOPs, and these are court cases that either participants bring against the company or the Department of Labor or will bring against an ESOP plan as well. The main thing is improper valuations, which is how a company's valued. It's very hard for a private company who is on a growth trajectory with some debt perhaps, as well as some long-term growth and things that are on the horizon to be profitable for the company. It's very hard for that to be valued correctly. And there are professional valuators who come in and write a valuation opinion. And a common legal action for an ESOP is those valuations to be based on things that, certain items are given more weight than they should have that impact the value of the stock to either be higher or lower than it should be. And so participants, the more information that a participant has about how a company is valued, the more risk you have as a company for being sued about that. And so the valuations, you want to explain to participants and link reward and risk and explain to them why the company is growing and how it grows and what they can do to help the company growth. But on the other hand, you don't want to put the company in a position that they could be sued because they've just handed over too much information to an employee that they can, you've basically outlined a lawsuit for them, and you don't want to do that. Another common legal action for ESOPs is a misuse of their assets. And a lot of times you see companies that have a profit-sharing plan as well as an ESOP, and they'll move assets between the two plans improperly. And that's another common legal action as well. Broken promises, such as changing the schedule for distribution of benefits, or if you've promised that the company is growing and then the next year they get the valuation of their stock and the stock has decreased. Those are kind of things that participants bring lawsuits about. So you want to be very careful when you are giving information that you're not making promises that someone could sue you over in the future. Another common legal action is excessive management enrichment, where a certain group of people profit too much to the detriment of kind of the rank and file participants. And the next one, accepting valuations that maximize the price the ESOP pays sellers by making only the most favorable assumptions, and that goes with the improper valuations. And the failure of the trustee to bargain aggressively with sellers to provide the best interest for ESOP participants, and that would be in a sale context when the company is being sold. So, courts have in the past questioned a heightened duty to disclose. So this question is still outstanding, and there's not really an answer for it yet. So you just need to act prudently. And the question is, should the company disclose business information to a participant who sold his shares of company stock he held in the ESOP after resigning? So after a participant is not an active employee any longer, his shares may still be in the ESOP plan for a period of time until the stock is revalued for the next year, or there can be a number of reasons that his stock remains in the plan. And the question is, how much information should you give that person? They're not an employee anymore, but they still have stock in the company. So ERISA generally does not require plan fiduciaries to disclose non-public business information to plan participants. And then I have two cases that have kind of gone on both sides of this issue. One court found there's no duty to disclose business information to people who have terminated, and then another court found that special circumstances will require a company to disclose information to terminated participants. So there's not really a right or wrong answer to this question at this point, which is why I wanted to highlight it. So when you have terminated employees that still are entitled to a benefit under the ESOP, that is a whole separate category that you need to think about what information are you going to give them. So if you're giving extra company financial information to all of your active employees because you're trying to motivate them and show them what they do in their day-to-day world impacts the value of their retirement benefit, the next question is what information do you want to give your terminated employees, because that motivation for them doesn't exist anymore. And so this is just a case-by-case situation, and we help employers deal with this from time to time. So with that, I am going to turn it over to David.
Great, thank you, Leah. So I want to talk a little bit more about who we are as a law firm, but I also, because we do have some extra time, Leah, I hope this is okay with you, I wanted to ask you a couple of quick questions.
Sure.
And I don't know nearly as much about ESOPs as you do, obviously, but one thing I do tell folks who ask me about ESOPs is that ESOPs are not a great plan for every company. So I was hoping that you could share with the audience, many of whom may not have a lot of exposure to employee stock ownership plans, what a prototypical company that could benefit from an employee stock ownership plan might look like, so that if there's an advisor out there or another attorney who has a client, or perhaps even a plan participant who has heard talk of an ESOP being offered at their business, give us a little bit of background on what
Sure.
a company like that might look like.
Sure. So before I answer that question, let me explain the huge advantage for an ESOP. So if an ESOP owns 100% of the company, that means the trust is the stock owner, and the trust would be the one to pay, as a shareholder, pay taxes, but because it's a non-profit trust, there's no taxes that the ESOP plan pays. So if you layer that with an S Corp, where the company pays no taxes and only its shareholders pay the taxes, and then the shareholder is a trust who doesn't pay any taxes. So if you have 100% owned, or all the shares are 100% owned by the ESOP, and you have an S Corp, then you have a company that never pays taxes. And so that's a huge advantage for a lot of companies, and really helps their bottom line. If you have a C Corp, as you know, a C Corp does pay some taxes. There's a lot of benefits and deductions that have been written into the tax code to make ESOPs still attractive for C Corps, but the S Corp is really where it's the most attractive, because you can have a tax-free entity that's a for-profit company, but yet doesn't have to comply with all the nonprofit rules. And so that being said, a lot of times you see, I think the best candidates for an ESOP is a company that has a lot of cash flow, because the way ESOPs typically work is the stock is the owner of the company, perhaps it's a single owner or a family, and does not want to sell to a competitor, so it sells its stock to the ESOP plan. Well, the ESOP plan, you know, and it's usually in the millions, it's usually profitable. So the ESOP plan goes and gets a loan to purchase the stock. And so you'd need a company that actually is making consistent profit on a yearly basis in order to pay off a loan of that nature, if that's the way it's structured. So you typically see ESOPs in a lot of kind of service or companies, construction, architecture, landscaping kind of things, where there's no inventory, where there's not a product they're necessarily selling. They're more selling a service, and there's a lot of cash flow there. That's not to say an ESOP would not be the right fit for a company that sells products. It's just generally you see it for service-related companies. You also see an ESOP plan does not have to own the company 100%. You can have a minority-owned ESOP. So if you have a family that owns a company and one person wants to sell their share, but the other family members don't, they could sell that to an ESOP, where the ESOP would be, for example, 20% ownership in the company, and the other 80% would be owned by the family members. So an ESOP is a great exit strategy for business owners who don't want to sell their company to a competitor, and they want their employees and their management team to kind of keep up the status quo or keep up what they've built over their career.
Great. So that was my next question, and that is simply, how are businesses using ESOPs as an exit planning or as a succession tool? And if you could just go into just a little bit more detail, then I think that would shed some light on that for me, especially.
Yep. Okay. So it's easier to talk about this in an example, probably. So think about a business owner who's in his 50s or 60s, and he's built a business, probably has 50 to 100 employees, maybe more than that, and he's getting ready to retire. His children don't want anything to do with the business, or maybe he doesn't want to give the business to his children. And he doesn't want to sell it to a competitor because this has been his life work, and he's built this up. So he'd form an ESOP. The company would sponsor an ESOP, and then he would sell his shares to the ESOP plan, which meant the employees would then become the owners of his company, whether he sold a minority share or 100% of his shares. It could be either way. The plan could go and get a loan from the bank to pay him, so he would get a lump sum of usually millions. And then as the company continued to make a profit over the years, it would pay back that loan. Or the owner itself may self-finance the sale of his shares, so that the plan, instead of paying a bank off, would pay the owner a nice little annuity, so to speak, for a number of years. And the owner, even after he sold the shares, could still be an employee of the company, and could still function as CEO or president or whatever he was. And so it's a great succession plan to get the money for a business a person has built, but yet still have some, if they wanted, it's not required, but if they wanted to still be engaged as an employee and still be involved in the company, they could. And that's how it's typically used in a succession plan.
Wow, you wrapped that up pretty nicely. So before we wrap up, Leah, I want to ask you one more quick question. And for the audience, Leah is an active member of an organization called NCEO. She spoke at the NCEO National Conference in Tampa this year. We as a firm will be present and active in the conference coming up in Atlanta, the National Conference in Atlanta, which will occur in April. And then Leah will be speaking again at another national conference next October in Albuquerque. So Leah, tell us a little bit about what NCEO is, what those letters stand for, and a little bit about how plan sponsors can benefit from attending one of those conferences.
Okay, sure. So NCEO is the National Center for Employee Ownership, and it is a national organization. It is not made up of entirely attorneys or evaluators who value the stock, or TPAs, third-party administrators, who do these benefit statements for employees. There are a lot of companies who participate as well, and they have seminars twice a year at these conferences, and it does not take place in the same city. It moves around the country, and they have seminars that are tailored to a wide gamut of people who are considering an ESOP but don't have one yet. Then people who have just had an ESOP, what do we do about it now? And then people who have had an ESOP for 10 or 20 years and are facing different issues. And so they have it's a great resource for wherever you are in the process, whether or not you have an ESOP or not. And so I've gotten a lot out of that organization, and I think a lot of companies who are not professionals in the ERISA arena or ESOP arena can benefit from it. I mean, they tailor a lot of their materials and their seminars to people who run companies and don't know much about retirement plans.
Great. You'll see and hear more about NCEO and our presence and activity in that organization as time goes on with our monthly HR alerts, as well as in future webinar broadcasts. So I did want to take a brief moment, Leah, to thank you so much.
Thank you.
Obviously, your knowledge is much deeper than mine on these topics. So thankfully, one of our core values, which I'll talk about in a moment, is experience. And certainly having Leah on the team has made all the difference in terms of the experience level that we can offer our clients. And I wanted to make it clear to our audience as well that our ERISA sub-practice areas include areas beyond ESOPs. We handle issues of employee benefits and mergers and acquisitions, executive compensation, health and welfare benefits in all their forms, healthcare reform and the compliance requirements around that, retirement plans and all the compliance and plan design around that as well. So as we talk about ESOPs and as we look at these different topics in a little bit more of a microscope in these webinars and lunch and learns, we want folks to remember that we do run the gamut here in terms of ERISA sub-practice areas. So please keep us in mind for these additional sub-practice areas. Our core values, as I mentioned before, include experience. All of our attorneys are very experienced. Most of them have large law firm backgrounds, but we're relationship driven. That means that you won't fall between the cracks if you're a smaller company. We are very responsive. We return phone calls. We respond to emails. And because of our experience, we can be efficient. Our fourth core value is mitigation of compliance exposure. We are proactive. What that means is that we would rather help you prevent a fire than help you put one out, but we can do either of those things. If you have any questions about the presentation, we will be sending every attendee a summary, a one-page summary description of the presentation today that Leah's put together for you, so that you'll be receiving that in an email. Please don't forget to fill out your 5-question survey. It will only take you 30 or 40 seconds to do so. And I wanted to also quickly plug, we have another webinar coming up December 19th at 2 p.m. That webinar topic will be peeling back the onion of fiduciary liability. This is really a hot topic in the benefits world with the introduction and then pulling back of the fiduciary rule. We're going to talk a little bit about exposure, jurisdiction, personal liability, our firm's annual fiduciary legal compliance reviews, investment fees and expenses, and how to benchmark those fees and expenses. We're going to be taking a look at specific case law, and we're also going to be doing joint analysis of a real case on which Hall Benefits Law and Verify teamed up. And so we hope that you will join ERISA attorney Ann Tyler Hall and Verify founder Al Otto for that webinar. You can be looking out for more information on that. That's going to be December 19th at 2 p.m. Each of you will receive a link to that as well. Thank you so much for your attendance. We hope you have a great day, and thanks.